And I invite Prashant to deliver this lecture. Thank you, everyone.
Thank you, Bhushan, and thank you to the All India Lawyers Association for Justice. And I'm so happy to see the kind of work that they've been doing and how this organization has grown in the last few years. It's very important to have such public interest organizations, especially of lawyers, which are willing to ask difficult and tough questions from the judiciary, from the government, and hold the government and the judiciary accountable. So, thank you for creating this organization and leading this organization, and all the people who are associated with this organization. So, the topic today is judicial accountability and independence. I'll first talk about judicial independence, and then talk about judicial accountability, and then mention a little bit about the connection between accountability and independence. So, the reason why the Constitution wanted an independent judiciary, independent means primarily means independent of the executive and independent of the legislature also. The reason was that because the judiciary has been given this important role of protecting fundamental rights of people and also ensuring that the executive and the legislature function within the bounds of their powers. Therefore, it is important for the judiciary to be independent of both the government as well as the legislature. And to achieve this independence, what the Constitution thought was required was that you make the judges of the High Court and the Supreme Court, these are the two constitutional courts who have been given this responsibility. You make them immune from disciplinary action by the government or by the legislature. And therefore, the government was not given any power to discipline judges. And the only method of taking any action against judges was supposed to be impeachment. And impeachment, as you all know, is a difficult process. Because to initiate impeachment, you need the signatures of 100 MPs of the Lok Sabha or 50 MPs of the Rajya Sabha on an impeachment motion. After that, the Chief Justice the government in consultation with the Chief Justice is supposed to, or rather the Speaker in consultation with the Chief Justice, is supposed to set up a judges inquiry committee of 3 judges, 1 sitting judge of the Supreme Court, 1 sitting Chief Justice of a High Court, and 1 jurist. They hold a trial of the judge. If they find the judge guilty, then only the things move further. And then it has to go for a vote in both houses of parliament. And it has to be passed with a 2/3 majority in each house of members present and voting, and an absolute majority of the total membership of each house. So it's been made a very difficult, almost impractical process, as a result of which, till today, no judge has been successfully impeached. So the constitution makers thought that this was adequate to ensure the independence of the judges from the government as well as from the legislature. After that, the Supreme Court added one further thing. They said that no, if the government enjoys the power to select and appoint judges, then they will select and appoint judges of their own liking, of their own ideology, and who are not very independent. Therefore, the power to select and appoint judges should be primarily vested with the judiciary itself. That was held in the second judge's case. And therefore, they interpreted the word consultation to mean concurrence, and they gave primacy to the judiciary itself in the matter of selecting and appointing judges. So now the law is that the senior 5 judges, 3 or 5 judges of the Supreme Court, it's called the collegium, they will select and recommend judges for appointment both of the High Court and the Supreme Court. Thereafter, the government has only one power, which is if they do not like a particular recommendation, they can send the name back to the collegium with their objections. And thereafter, if the collegium unanimously reiterates the names, then the government has no option but to appoint those judges. This is the law laid down by the Supreme Court. So, it was realized that appointment can also, the power of appointment being with the government can also affect the independence of the judiciary, and therefore the power of selection and appointment was primarily taken away from the government and vested essentially with the collegium of senior judges. It was thought that this will ensure the independence of the judiciary. But if you look at the situation today, especially what has happened in the last 10 years, we are increasingly finding that a large section of the judiciary, of the High Court judges and the Supreme Court judges, are not functioning very independently. And they are largely doing whatever the government wants them to do. So they are failing to protect fundamental rights of the citizens, as a result of which many very honest, honorable citizens, some of our best activists, human rights activists, have been languishing in jail for years without trial, without getting bail, as a result of which many people who speak out against the government and who are arrested on charges of sedition or some other UAPA, etc., are also kept in prison for many years without being granted bail, even though the Supreme Court has held that bail is the rule and jail is the exception. So unless you can show that there is some good reason to keep somebody in jail, you can't. You'll have to release him at least on bail, even if the case or the charge against him is going on, or it is at a trial stage, or it is at an investigation stage, etc. So we are seeing an across the board failure. So there is so much discrimination against minorities in this country being practiced by the governments wherever the BJP is in power, especially where the BJP is in power. We are seeing mob lynching, we are seeing bulldozing of homes of people from the minority community, etc. And by and large, the courts have also been unable or unwilling to stop all that. We are also seeing that in many cases involving corruption of the government, like the Rafale deal or the Birla Sahara case, which were crying out for an independent investigation, or even in this electoral bonds case, where it has been proven without doubt that most of the people who gave thousands of crores by way of electoral bonds to the various governments, particularly the BJP, which received more than half of the electoral bonds, have given it by way of a bribe for securing contracts, or for getting ED and the CBI off their backs, etc., or for getting the drug controller off their backs. But still, no independent investigation has been ordered. Nobody has been held accountable. So we are seeing, I'm not saying that there is no independence of the higher judiciary at all. Fine judges like Justice O or some other fine judges have taken action to uphold the independence of the judiciary, and sometimes done things to stop the government from this kind of lawless trampling on the rights of people. But by and large, in the last 10 years especially, we have seen a great decline in the independence of the judiciary. Now, why has this happened? We need to understand why this has happened. So, one reason is that when you have a strong fascist government staring at you, staring down at you, then only judges who have what Justice Oak said, spine, spine and spine, only they are able to stand up to a strong and fascist government. The weaker judges are afraid that they are afraid of the government doing something to them, to their family members, etc. And they kind of buckle down in the face of this fascist, strong fascist government. This happened during the emergency when we saw the Supreme Court kind of bending to the government in the habeas corpus case. And even in Mrs. Gandhi's election case. So, and it is happening even now. Because this Modi government has been as strong and as fascist, even though today they don't enjoy a majority in the Lok Sabha, still, because its partners, which are the other political parties from Bihar and Andhra, they have kind of almost given a blank check to this government to do whatever they want, and these people are certainly fascist. And therefore, today also we are seeing that a lot of judges who lack that spine, that strength, they are not able to stand up to the government and resist what they want. The second reason was spelled out by Arun Jaitley himself in his speech in Parliament, in his famous speech in Parliament, where he said that post-retirement jobs to judges affects their pre-retirement judgments, which is totally true. So we are seeing that this present government has used this business of post-retirement jobs for judges to influence the judgments and the actions of many judges. I mean, I can give you a few examples. So take Justice Gogoi, who decided the Ram Janmabhoomi case in favor of the government. He decided the Rafale case in favor of the government, where he took on board unsigned notes handed over in a sealed cover by the government, and on the basis of that delivered a judgment in favor of the government, where he said, repeated the falsities which turned out to be falsities which were handed over to him in a sealed cover. The judgment contains several false statements, because those were the false statements, demonstrably false statements made by the government in that unsigned note handed over in a sealed cover, which was relied upon by Justice Gogoi to give that infamous judgment. He was made a member of the Rajya Sabha immediately after retirement. Then we have the case of Justice Arun Mishra. Now Arun Mishra delivered the Birla Sahara judgment in favor of the government. He delivered the land acquisition judgment in favor of the government. He delivered any number of judgments in favor of Adani, giving Adani a favor of at least 20,000 crores, benefit of at least 20,000 crores. All at the instance of the government. I mean, I don't know whether he took any bribe or not, I can't say, but certainly at the instance of the government. And that gentleman was made chairman of the National Human Rights Commission soon after retirement. Then you have the case of Justice Khanvilkar, who delivered a judgment against Neesta Setalwar, asking her to be prosecuted, delivered a judgment against Mr. Himanshu Kumar in the Chhattisgarh harassment and encounter and fake killing of tribals, etc., ordered an investigation against Himanshu Kumar, who delivered several judgments on PMLA, making the Prevention of Money Laundering Act even more draconian. None of these people delivered a single important judgment against the government. And this gentleman, Hanvilkar, has been made Lokpal. Then you have several judges who were appointed governors. Justice Satashivam, who gave bail to Amit Shah, gave bail or gave some benefit to Amit Shah in that fake encounter case of Gujarat. He was made governor. Now Justice Nazir, who gave this Ram Janmabhoomi judgment, he has also been made governor. So this post-retirement jobs has been used as an instrument again to influence the independence of several judges. Then you have the issue of appointments itself. See, under the law, the Supreme Court has said that appointments of judges have to be primarily selection and appointment is the job of the judiciary, of the collegium. The government plays a very limited role in that business, which is, if they object to any name, they can send it back to the collegium. Thereafter, if the collegium unanimously reiterates, they have no other option but to issue the appointment order. What this Modi government has done in the last 10 years, whenever they find that the collegium has recommended a judge with spine, or if they have recommended a judge who is not of the ideology of this BJP RSS, does not follow communal ideology, or has recommended a judge of the minority community, that is either Muslim or Christian, or has recommended a judge who is totally honest and who cannot be influenced because of his dishonesty, then the government just sits on that recommendation for years altogether without appointing and without sending the name back with objections. Sometimes the Chief Justice prods the government, repeatedly prods the government that we had sent this recommendation, why have you not responded? And then, even when the government responds by saying that we object for this reason, and thereafter the collegium reiterates the same name unanimously, even then, there are dozens of cases where this government has not issued the notification. Now, this is a situation in which the judiciary should either say that, look, whether you issue the notification or not, it will be a deemed appointment once the collegium unanimously reiterates, and therefore we will administer the oath to the judge irrespective of whether notification has been issued or not. This is one option. The other option is that they should call up the law minister or the prime minister, whoever is holding up the file, for contempt of court, and they should threaten to send them to jail if they do not issue the notification. But unfortunately, the judiciary, Supreme Court has not been strong enough to take either of these two options and have just allowed the government to scuttle the appointment of independent judges with spine, or minority judges, or honest judges who are ramrod straight and who cannot be influenced for extraneous considerations. But the last and the most important method which this government has adopted to bludgeon the independence of judges is of preparing dossiers against judges and their families. This government, I know, has instructed all the agencies under their control, the ED, the CBI, the NIA, the income tax, the police, everybody, to prepare dossiers on important judges, especially those judges who are in line to become Chief Justices of the High Court or the Supreme Court. And if they find any weakness in that judge or any of his close relatives, they have done anything wrong or illegal in their past, then that information is used to blackmail those judges and bludgeon their independence. And if that judge happens to be a Chief Justice, if they happen to catch a Chief Justice in doing something wrong, they caught Justice Gogoi, they caught Justice Deepak Mishra, then, of course, half the judiciary comes under the control of the government. Because the Chief Justice is not merely the first among equal in the Supreme Court, the Chief Justice of India. He plays two other exceedingly important roles. First, he is the master of roster who decides which case is to be decided by which bench. And thus, everybody knows, everybody without exception in the Supreme Court knows which judge is independent, which judge has spine, which does not have spine. Which judge is ideologically committed to the government, which judge is not committed to the government. Which judge is honest, which judge is dishonest. And therefore, if the government wants a particular politically sensitive case to be decided in a particular manner, all that it has to tell the captive Chief Justice is that please send this case to this bench, and it is duly sent to that bench by that captive Chief Justice to secure a particular result. So, that's the first important role, additional important role of the Chief Justice. The second role is that he is the prime mover in judicial appointment. So when the collegium makes a recommendation that we decide to select these 5 people to be appointed judges, that file has to be sent to the government by the Chief Justice. He finally signs it and sends it to the government. But if the Chief Justice is in the pocket of the government, under the control of the government, then, and if the government does not like the recommendations that have been made by the collegium, then the Chief Justice exercises what is called a pocket veto by just keeping that recommendation in his pocket. He has no such power, but he exercises this extra legal power by just keeping the recommendation in his pocket. This has happened. Justice Gogoi did it when 2 High Court Chief Justices were recommended for appointment, Justice Nandriyog and one other judge, by the collegium, and Justice Lokur has come on record to speak about this. Gogoi just kept it in his pocket, didn't send it to the government, that recommendation of the collegium, because the Gogoi was completely controlled by the government. So, if you control the Chief Justice of India, you control virtually half the judiciary. And unfortunately, Mr. Bhushan, who just decided to retire from active practice, has recently given an interview to Karan Thapar in which he has pointed out how in the last 10 years the independence of the judiciary has been bludgeoned, and primarily by a succession of 5, 6, 6, 7 Chief Justices who, one way or another, came under the influence of the government. So, in this manner, the independence of the judiciary in using, because of these 4 reasons which I have just outlined, strong fascist government and weak judges, secondly, post-retirement jobs, Thirdly, not allowing the appointment of independent judges by just sitting on the recommendation, or yes, by just sitting on the recommendation. And fourthly, by the government preparing dossiers, etc., and then using those dossiers to blackmail judges who have some chink in their armor. Justice Sanjeev Khanna didn't have any chink in his armor. And therefore, he functioned as an independent Chief Justice. They could not blackmail him. They must have tried to find some chink in his armor, but they couldn't get any chink in his armor. It's another matter that he was a generally conservative judge, but he was at least independent. He could not be blackmailed by the government. Now we come to the issue of judicial accountability. You see, in their effort to secure judicial independence, the constitution makers essentially made the judges unaccountable, because judges quickly realized that this impeachment, etc., is all impractical. And like Justice V. Ramaswamy, where impeachment went quite far, because more than 100 members of the Lok Sabha signed the impeachment motion. A good inquiry committee was appointed of Justice Sawant, Justice P.D. Desai, Justice Chenappa Reddy. They held him guilty on many counts. But when the matter went for vote in the Lok Sabha, he used his political connections with the Congress party to get the Congress party to abstain en masse, with the result that Congress had a majority in the Lok Sabha, and therefore, while the motion was unanimously passed in the Lok Sabha, it couldn't secure a majority of the total membership of the House. Therefore, judges have come to realize that they are essentially not accountable to anybody. Of course, there have been occasional cases, like the recent case of Justice Yashwant Verma, where fortuitously this video of the money being burned, sacks of money being burned in his outhouse, etc., of his house, came out into the public eye. If it had not come out in the public eye, I don't know what would have happened. I don't think that the case would have come this far. But because it came out in the public eye and it became very difficult to contain this scandal, therefore, he was transferred, he was told, the Chief Justice was told not to assign him any judicial work, the High Court Chief Justice, and an inquiry committee in-house inquiry committee of 3 judges was appointed. This is not in terms of the impeachment proceeding. This is separately. What the Supreme Court did in 1997 when Justice J.S. Verma was the Chief Justice. In a meeting of all the Chief Justices of the country, they created a code of conduct. And in that code of conduct, they also created a system by which complaints against High Court or Supreme Court judges could be made to the Chief Justice. And the Chief Justice would take a call whether the complaint was serious enough to merit an inquiry. And then the Chief Justice was given the power to set up an in-house inquiry committee of 3 judges. Usually it is 2 Chief Justices of High Courts, if it's a High Court judge, 2 Chief Justices and one other person, one other judge. So in this particular case of Justice Yashwant Verma, that in-house inquiry committee under this code of conduct was appointed. And they have conducted proceedings, heard a large number of witnesses, and given a report against him. As a result of which, finally the committee and the Chief Justice have recommended his impeachment. Of course, in this situation, there should have been an FIR against him, there should have been a proper criminal investigation against him. And on that, by another judgment, the Supreme Court, or the Veeraswamy case, the Supreme Court had said that no FIR can be registered against a sitting judge without the permission of the Chief Justice, because otherwise the police, which is controlled by the government, can be used to harass innocent judges if the government wants to harass. Now, fair enough, I understand why the government should not have an unlimited right to register FIRs and investigate and harass judges, etc. But see, the problem that we have seen in all in-house cases and in this business of FIR is that you have to write to the Chief Justice. The Chief Justice of India has to decide whether this warrants an in-house inquiry and whether this warrants an FIR or not. And I, as the convener of the campaign for judicial accountability and reforms, have sent complaints against at least half a dozen judges. Very serious complaints, accompanied with documentary evidence, saying that this matter requires a proper in-house inquiry. But in each one of those cases, no in-house inquiry has been ordered, and the complaint has just been thrown into the dustbin, despite the fact that the complaint was a very serious complaint, accompanied by voluminous documentary evidence against that judge, and yet no in-house inquiry was done. Nor was ever any permission given to register an FIR against the judge. Even in this particular case, no permission has yet been given Yashwant Verma's case to register an FIR against the judge. So, what we have in effect is a judiciary which is essentially unaccountable. High Court and Supreme Court judges who have no accountability whatsoever. And when you have a situation where judges begin to feel that they are unaccountable to anybody, then this corruption grows. Because, Justice Yashwant Verma's family I know for the last more than 60 years. I know every uncle and aunt of this family. It's one of the most respected and upright families of Allahabad. Yet, unfortunately, it is clear to me that yes, money was found at his house. The explanation that he has given for that money being found is a false explanation, and therefore, in my eyes also, he is guilty. How has it happened that a young man, a judge coming from such a respectable family, a reasonably well-to-do family, who had a good practice as a lawyer also, has turned to corruption? How has it happened? Why is it happening? And one of the main reasons that this is happening, and it's a virus that is growing across the judiciary. At one time, the Delhi High Court used to be regarded as one of the very honest high courts in the country. But today, I see that there is rampant corruption even in the High Court, in the Delhi High Court. Gradually, this virus of corruption has spread across the board. And it has spread across the board because they feel that there is no accountability. There is no check upon them. And gradually what happens is that one corrupt judge, other honest judges, Yashwant Verma also may have got into the company of some corrupt judges, thereafter in the company of corrupt lawyers. There are unfortunately, at least in Delhi, I can see a very large number of fixer lawyers operating in the High Court and in the Supreme Court, whose job is only to fix cases by corrupting judges, etc. So if you get into the company of these fixer lawyers and corrupt judges, etc., it's easy to slip because they will tell you, sir, you are giving the right judgment. For the right judgment, somebody is willing to pay you some few crores, then what's the problem in taking those few crores? Just take it. Nobody is going to hold you accountable. So this is what has happened. Now, once the government had brought this bill called the Judicial Standards and Accountability Bill, where the main thrust of that bill was that apart from impeachment, one other method is available for effectively starting the process of impeachment. One method is 100 MPs sign or 50 MPs of the Rajya Sabha sign. The other method was that you make a complaint to the Chief Justice, the Chief Justice forms a committee, if that committee recommends that the judge is guilty, then the impeachment proceedings are triggered automatically without MPs having to sign. But that those committees were also in-house committees of judges. See, if it is a complaint against a judge of the Delhi High Court, the committee was two judges, sitting judges of the Delhi High Court, and one other judge. Now, all these judges are whining and dining together every day. They are going around in each other's company every day. So it's unnatural to expect that sitting colleagues of judges, even if that judge is corrupt, very rarely will it happen that sitting colleagues will honestly indict a corrupt judge if they are their sitting colleagues. So therefore that bill did not fly, it kind of fell by the wayside. So today we are reduced to that impeachment or in-house, and both I have said, impeachment is impractical, in-house has conflicts of interest. You see, what happens is, even the most honest Chief Justice, I know of a Chief Justice who is from Bangalore, who is considered the sort of Bhishma Pitama of the judiciary, who is one of the most honest Chief Justices of India that we have seen. My father once asked him about a Calcutta High Court judge who was known to be thoroughly corrupt. And Chidambaram, when he was Minister of Commerce, had made a complaint against him. For Chidambaram himself is a man with a shady reputation, but that judge of the Calcutta High Court was known to be corrupt. And so well known to be corrupt by even this Chief Justice that every time that there was an appeal against the judgment of this judge before the Chief Justice, without asking any question, he would issue notice and stay the judgment of the High Court, because he knew that this judge was thoroughly corrupt. So Chidambaram asked for his permission to register an FIR, but he didn't grant that permission. He didn't grant that permission because he felt that if he grants that permission to register an FIR and if there is an investigation against that judge, the judiciary will come into disrepute. Therefore, he didn't grant that permission. So he said that no, Chidambaram, when my father asked him, he said that no, Chidambaram had not given me any evidence, etc. So my father told him that look, if you knew that he was corrupt, he asked him, do you feel that he was corrupt? He said, yes, he was thoroughly corrupt. So he said, all right, if you knew that he was corrupt, even if Chidambaram had not given you all the evidence against him, why didn't you? He was only asking for permission to register an FIR. Why didn't you give that permission? But the real reason was he felt, and this is the feeling of a lot of judges, of a lot of Chief Justices, they feel that the judiciary is one family, it's a judicial family. And the whole family gets defamed if there is investigation and if there is a scandal associated with any particular judge. And therefore, they don't want this scandal to come out. Of course, when it inadvertently comes out, when it came out in the case of Yashwant Verma, then they had to act. But otherwise, they don't want to act because they feel that they will just contain it and at best transfer those judges. So there are a number of transfers which have taken place recently of High Court judges. Why are those transfers being done? Mainly because there was evidence to show that those judges are corrupt. But transfer is no solution to corruption. So therefore, we need a different system for accountability. What we need is a totally independent, that is independent of the government and independent of the judiciary. A totally independent Judicial Accountability Commission or Judicial Complaints Commission consisting of 5 people who can be drawn from any walk of life. They can be retired judges, they can be other public people who are selected in a manner by a broad-based selection committee so that the government plays a very minimal role in their selection. And the sitting judiciary also plays a minimal role in their selection. So that it's a broad-based selection committee. And they select 5 people who form the Judicial Complaints Commission. This Judicial Complaints Commission should have the power to examine complaints against judges coming from anybody, and thereafter order either an investigation or a trial. If they feel that there is enough evidence against that judge, they hold a trial of that judge, and thereafter they recommend his removal or whatever action they want against him, and that should automatically follow. That should be the system for accountability of judges. But unfortunately, you see, the judiciary is not interested in having independent accountability. They are very happy to be unaccountable. And the government is also not interested because the government wants corrupt judges. Corrupt judges are the easiest judges to blackmail and bludgeon their independence. Government wants corrupt judges. So therefore, neither the judiciary nor the government wants any accountability for the judiciary. And that's why I keep saying, ultimately, who are suffering? The sufferers are the common citizens of this country. And I agree with Justice Chandru that the citizens are the real consumers of justice in the country. And they have the maximum stake in ensuring that there is an independent and accountable judiciary. And therefore, unless there is a people's movement on this issue of judicial independence and judicial accountability, we are not going to really see any movement on this issue at all. Because, as I said, nobody seems to be interested. Only the citizens are the people who are suffering. The consumers of justice are suffering. So, now lastly, the connection between judicial independence and judicial accountability. So what happens is that when you have lack of accountability, you have corruption. And when you have corruption, corrupt judges cannot be expected to be really independent because they can be blackmailed, they can be bought, they can be influenced in multifarious ways, and therefore an honest judiciary, an accountable judiciary is essential to ensure the independence of the judiciary. And as I said, the only way that this will happen if there is people's movement on this issue, if there is, having a functioning, independent, accountable judiciary is essential for every citizen of this country. Because ultimately it is the judiciary which is to protect fundamental rights of citizens and to ensure that the executive and the legislature remain in function within their bounds. And therefore, we will have to somehow create a people's movement if there is to be any movement on this issue. So thank you very much.
Thank you, Prashant. I think we can have a round of questions now.